Here's something that surprises almost every Texas landlord. There is no law in this state that requires you to give your tenant advance notice before entering your own rental property. Now, before you go making copies of your key, that doesn't mean you can show up whenever you want. What it means is your lease is doing all the work here. And if your lease isn't written right, you're flying blind. I'm Michael with Darling Property Management. We manage residential rentals across Dallas-Fort Worth. Today, we're walking through exactly what Texas law says about landlord entry rights, what's actually in the property code, what's missing, and what you need to protect yourself. Let's go straight to the statute. Texas Property Code Chapter 92. That's the chapter governing residential tenancies in this state. Read it front to back and you won't find a section that says landlord must give 24 hours notice before entry. That section doesn't exist. Compare that to California, where landlords are legally required to give at least 24 hours written notice, or New York, where the same rule applies in most situations. Texas doesn't have that. Texas leaves it to your lease. That said, Texas courts have consistently recognized something called the tenant's right to quiet enjoyment. That's a legal doctrine. Your tenant has a right to actually live in the property without constant disruption. You can't show up 3 times a week. You can't use unlimited access as leverage over a tenant you want gone. A judge would not look kindly on that. But the specific notice period, that lives in your lease. And if your lease doesn't address it, you're operating in gray area. If your lease says landlord will provide 24 hours written notice before entry, that's a binding contract. Both sides are locked in, even though the state didn't require it. If your lease is silent on entry, Texas courts will look for what's called reasonable notice. Nobody's officially defined that in statute, but 24 hours is the widely recognized industry standard for non-emergency situations. The problem with a vague lease, a tenant who feels their privacy was violated can make things difficult even without a clear legal violation. The fix is clean, specific lease language. I'll get to exactly what to put in there in a few minutes. But one thing worth knowing, Texas passed the House Bill 2037 last year in 2025. Among other things, it clarified that required notices can now go by email, as long as both parties have previously communicated that way. So if your tenant's been emailing you, sending a notice to enter via email is legitimate. Good to know when your lease specifies written notice. One clear and obvious exception is emergencies. A pipe that burst, gas smell, fire, any immediate threat to the property or the people in it, you can go in. You don't wait 24 hours while a kitchen floods. What actually qualifies? Active water damage, a gas leak, fire, structural hazard, carbon monoxide alarm. It does not mean, I think something might be off or I want to do a quick walkthrough. The threshold for no notice entry is a genuine, time-sensitive emergency. Here in DFW, HVAC failures in the summer can get there. Texas Property Code defines the habitability standards landlords are required to maintain. And a non-functioning AC, when it's 103 degrees in Texas, is in fact a habitability issue under Texas law. If a tenant reports a broken AC on a Friday evening and you can't reach them, going in to assess is defensible. Either way, document your entry. Text the tenant, send an email, write something down. Even when you're not legally required to, that paper trail will protect you. 3 clauses we put in every lease, and we recommend you do the same. The first one, notice before entry. Landlord will provide at least 24 hours written notice before accessing the premises, except in cases of emergency. It's clean, it's specific, and it's enforceable. Number 2, permitted reasons for entry. List them out specifically. Repairs, inspections, showings to prospective tenants, emergency access. This eliminates the "you had no valid reason to be there" argument before it starts. 3 is the notice method. With the new House Bill 2037 that I mentioned earlier, email counts if you've been communicating that way. You can also include text. Be specific about what qualifies as written notice. I tried to call, doesn't cut it. If you're using the standard Texas Realtors form like we use, that's the TXR 2001, there is a basic access clause already in there. Review it carefully, make sure it's specific enough for your situation and that your tenant understands exactly what they signed. Regardless of what your lease says, there are lines in Texas law you cannot cross. Texas Property Code Chapter 92, that's the lockout and utility statute, specifically in Section 008. It is explicitly illegal in Texas to lock a tenant out, remove doors or windows, or shut off utilities to pressure someone into leaving. That's a self-help eviction. If you do it, the tenant can sue for actual damages plus attorney's fees. Using entry as a harassment tool, showing up repeatedly with no legitimate repair or inspection purpose, falls into the same territory. Even without a specific entry statute, a pattern of intrusive access can be found to violate quiet enjoyment. That can give the tenant grounds to walk away from the lease. That induces vacancy, turnover, potential lawsuits, all at once. The standard here isn't complicated. Be a professional. Give notice. Keep entry purposeful. Document it. Document your conversations. That protects you legally and keeps the landlord-tenant relationship intact. Here in the great state of Texas, landlords have more flexibility on entry than most other states. But that flexibility only works in your favor when your lease backs it up. Without a solid clause, you're operating in gray area that can turn into a real dispute fast. If you own a rental property in Dallas-Fort Worth and you want to make sure your leases are airtight and your properties are managed by someone who knows this property code, we'd love to talk. There's a link in the description for a free rental analysis. No pressure, no obligation. We'll walk you through exactly how we'd handle your property. If this was useful, hit subscribe. We put out new content every week for North Texas landlords. Thank you for watching. We'll see you next week.